It's been quite an interesting day. Apparently it's already been misinterpreted by some in the media. And I hope that though so many publications have had to cut their research budgets and cut their staffing budgets, I hope that those that still are blessed to work for journalistic institutions will do the proper homework and understand better about the Gohmert, Landry, Rigell amendment that passed today and the effect that it had on the underlying NDAA, and more particularly the authorization for the use of military force that was passed after 9/11 by both houses of Congress. Now, I wasn't here, nor were any of the 5 co-sponsors. See, Mr. Duncan, freshman, Mr. Barletta, freshman. They weren't here, nor were Mr. Landry, Mr. Rigell. So besides me, we had 4 freshmen on the Gohmert, Landry, Rigell, Duncan, Barletta amendment. I felt compelled to make my amendment to deal with an issue that was raised not in the National Defense Authorization Act that was passed some months back. Some people failed to understand, really, the NDAA that was passed previously did not give the president the power to indefinitely detain American citizens. And as we understand, a judge has ruled recently that any interpretation that it gave the president that power was unconstitutional. I don't know how that will come out, but I do know after we were attacked in the worst attack on American soil ever, the country, I recall I was a judge at the time, the country was in a great deal of chaos. Planes were ordered not to take off all over the country. Those that were coming in couldn't come in. We had American citizens stranded at airports around the world. But what's worse, we had over 3,000 Americans who were dead, done by people who believed their radical interpretation of Islam dictated that they should go about killing innocent Americans and others who happened to be on American soil at the time. Didn't seem to bother them. Some of them could have even been Muslim. Didn't seem to bother them because they had this sordid belief that they would end up in paradise with whole dozens of virgins. Thank God most Muslims don't believe that. The trouble is there are radical Islamists that do. So the Congress, September 18th, a week after this worst attack on American soil, passed a joint resolution, Public Law 10740, and it was to be cited, as it says in Section 1, as the, quote, authorization for use of military force. And, Mr. Speaker, I'm going to go to the trouble to read Section 2A because sometimes there are reporters who don't do their homework. They think reporting means rather than digging and reading things for yourself and getting the clear meaning of legislation for yourself, that's not nearly as effective as lazily asking somebody, what do you think this does? So we get polls, we get surveys, we get opinions, but having been a judge and a Chief Justice, You didn't do that as a judge. You didn't do that as a justice on an appellate court. You had to look at the law and say, what does it say? And what does other laws in which this may be in context cause it to mean? And look at it for yourself. Most of these folks, they're educated, and so I hope they will take a look for themselves. Those that were most concerned that the NDAA from months ago gave unbridled power to the president, what really concerned me as a former judge and Chief Justice was reading the Section 2A authorization for use of United States forces. And again, you know, it's hard to fault folks because it was a week after this horrible attack when we weren't even sure who attacked us and why they attacked us. Gotten a pretty good idea early on, but so 1 week after September 11, 2001, this joint resolution is passed into law. Section 2A says in general that the president is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. Now, as I understand, I haven't read the opinion this week from district court, and the district court, it's not like that carries the weight of the Supreme Court or even a court of appeals, but Congress really appears to have given the president unbridled, unlimited, indefinite authority to just detain, arrest, do whatever had to be done to protect America from further attacks. And as we know from history, it's after such horrible attacks or incidents and other times in history when there is a temptation to overreact and to give too much power to one body or one person, and later on when things are calmed down and people are caught that perpetrated the horrible act, we realize, uh-oh, we lost a lot of our rights. We lost a lot of our powers because we placed them in one person. And this is what the Section 2A did. That's the way it struck me when I first saw that after I got to Congress, and that was a matter of concern. And it wasn't until the NDAA, I'm not on armed services, it wasn't until the NDAA came up that I really started researching and seeing exactly what this said and did. And I'm sure Speaker Boehner would be the first to tell people that he and I often do not see eye to eye, but he gave me the assurance that if the NDAA passed, he would let me come back with an amendment that would fix the AUMF so that a president did not have the power, unlimited power, indefinitely, to detain American citizens on American soil. So that was the impetus for trying to prepare a proper amendment that would deal with the main problem, the unlimited power of the AUMF, but also dispel concerns that people may have with the National Defense Authorization Act. That was going to have to be replaced, redone, reauthorized, and I'm glad to say the Speaker kept his word, and we were and we were allowed to bring forward a fix. My friend Justin Amash and I have many times in his year and a quarter or so of being here have consoled each other as being one of only 2, 3, 4, 5 who voted for or against a bill, and we're kind of out there by ourselves. So I was not surprised to see that Justin Amash was trying to work on an amendment that would fix the same concern that he and I had. Now, I think his concern, and he could speak more accurately toward this, but I think his concern was more with the NDAA. Mine was more with the AUMF. This grant of power was far too unbridled. It needed restraint. We are blessed here in Congress to have people who have served in so many walks of life, been blessed in a number of different ways. And it's great to have such diversity, not just race, creed, religion, gender, but actually differences of opinions and divergent backgrounds. And we have a prayer breakfast every Thursday morning on Capitol Hill. And it is really a blessing to hear other members, Democrats and Republicans. We take turns speaking at prayer breakfast, one from the Democratic Party, one from the Republican Party each week. And it is just incredible the way God has moved in lives and taken people, whether it's from being a school teacher or being a ditch digger, all kinds of things, to propel them in life and ultimately land them here in Congress. It just happens that I've been blessed, not with extraordinary intelligence, but with having been around people with extraordinary intelligence, including brilliant people who have tremendous intellect and insight into our Constitution. I never expected to be in Congress. I just liked history and knew I owed the Army 4 years from a scholarship at Texas A&M, and I had the luxury of majoring in history. So I got to study under some incredible historians who gave a different perspective on our Constitution, rather than a legal perspective, a historical perspective, and brilliant people on policy throughout the history of man. But when one reads this and one does not understand the Constitution and the powers that are granted to Congress under the Constitution, one can get the wrong impression. I've heard friends that I think tremendous amount of here in Congress who have said such things publicly as every American citizen, every person. The bill talks about persons. Well, yeah, in some places it does. But they have the idea it refers to persons in every place. It doesn't. They say every person is entitled in America to go through before an Article III court. And I appreciate and understand that misinterpretation. But when one reads Article 3, Section 1, what it says is, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So the Congress has the authority never to even create a federal district court. The Congress has the power to eliminate every federal district court if it so chose. I am very grateful that Congress has not chosen to eliminate every federal district court. But nonetheless, the power is there to create or not create federal district courts. The Supreme Court has even spoken on this issue before and has made clear that the power is entirely in Congress's hands. As my former constitutional law professor, David Gwynn at Baylor Law School, used to say, there's only one court in the United States that owes its origin to the Constitution, and that is the Supreme Court. Every other court in the country that is a federal court or tribunal or commission owes its existence to the Congress. Now, I have tremendous regard for President George W. Bush. He is a brilliant man, despite what some people think and jokes that were made at his expense. He's a brilliant man, one of the wittiest people you can be around privately. It's just a real joy to be around, but he got some bad advice. He had people who were lawyers who told him, hey, Mr. President, let's just have the executive branch set up a military tribunal and let the military tribunal try terrorists, whether American citizens or whatever. Let's set up tribunals here in the executive branch. Well, they had failed to notice that in Article 1, Section 8 of our Constitution, it says the Congress shall have power to lay and collect taxes, and it goes on down and says to constitute tribunals inferior to the Supreme Court. So, really, you could arguably have a federal district court that is set up inferior to the Supreme Court under Article 1, Section 8, just as you could under Article 3. I know there's some that say, well, no, those are Article 3 courts. Well, Article 1, Section 8 really seems to indicate you could call them a federal district tribunal. You could establish those inferior courts under the Supreme Court under Article 1, Section 8. Congress is also immediately under that given the power, shall have the power, it says, to define, punish piracies and felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. We got the power to make those rules of anybody who is captured on land or water. Power to create the courts. We got the power, we shall have it, to establish uniform rules of naturalization. We have the power to dictate policy here in Congress by our legislation with regard to immigration. We have the power under this Constitution, it's been determined over and over again, that we can say to immigrants legally and illegally in this country, you don't get a hearing in front of a federal district court. You must go to the court we have set up over here that's inferior to the Supreme Court, but we're calling it an immigration court. In other cases, somebody's broke, we're given the power to set up bankruptcy courts. And it's a sad testimonial for our country that a man that's sometimes referred to as the revolution's financier, there are actually a few different sources. One was France. One was a Jewish gentleman without whom many say we could not have afforded the revolution. And another was a man from Philadelphia named Morse. Morse, in fact, if one goes down the hall to the rotunda and looks up, one of the paintings that's painted into the plaster 189 feet up there at the top of the dome, is supposed to be a depiction of Morse with a money bag depicting him loaning money to the revolution to keep things going. And Mr. Morse ended up, after the revolution, doing well, worked out great for him, but because things were going so well in the country, it looked like they were going to, he had bought a lot of land. And a lot of land, Virginia and up around this area, around where the District of Columbia would ultimately be, and he had gotten overextended, and he was broke, and he couldn't pay his bills. And so he ended up in a debtor's prison in Philadelphia. A man to whom we owe so much for having a successful revolution, so people, as our founders said, for the first time, truly the first time, would actually be able to govern themselves. And a principal financier ends up in debtor's prison in Philadelphia. And yet the Constitution itself had said Congress would have the power to create uniform laws on the subject of bankruptcies throughout the United States. But it wasn't till after Morris got thrown in debtor's prison, and he had been there for long enough that it destroyed his health, it ruined him as a man, that he ended up believing all was lost, dejected, when someone in Congress realized, wait a minute, our Constitution gives Congress power to create bankruptcy courts. Maybe we ought to created bankruptcy system, and Mr. Morris was released from jail, but he was in such poor health he never really enjoyed the freedoms that he had financed. So there are so many powers in this given to the Congress, creating courts, not creating courts, creating tribunals, not creating tribunals, and that's why, and I know there are friends of mine that were in the Bush administration that disagree with me, but the Supreme Court, I believe, got it totally right when they told the Bush administration, you don't have the right to create tribunals to try terrorists. You don't. The Constitution, Article 1, Section 8 says that the Congress shall have the power to constitute tribunals inferior to the Supreme Court, not the President. That's not in Article 2 under the executive powers. It's not in Article 3 under judiciary powers. The power to do that is in Article 1, Section 8. You don't have it. So until Congress comes up with military commissions or tribunals, they're not constitutional. And so in 2006, not long after I got here, people prepared, and through our committee judiciary, a military commission act that was constitutional because Congress did this. And